with some opening remarks before we get started. And as many of you have just heard, the session will be recorded. Looking forward to it, and thank you. Over to you, Fernando.
Thank you, Themba, and good day, everyone. It's really a pleasure to be here today for the launch of the People-Centered Justice Practice Notes. Thank you, everyone, for joining and taking the time to engage in this conversation. On behalf of Pathfinders, I would like first to start really thanking our co-sponsors for the event today, the government of Sierra Leone and the Open Government Partnership and UNDP. And just to say that while the process of developing this practice note was led by Pathfinders, we have to start acknowledging the widely consultative process that took place. So I would like also to start thanking all those who contributed to this process and gave really many hours of their time to refine their documents. But I would be very unfair if I don't name a few particular people who has dedicated a lot of time to producing and finalizing this note. In particular, I'd like to mention Georgia Georgievich, Evelyn De Brown, Laura Ospina, Themba Mashleka, Nate Edwards, and Leah Bouillot and thanking them for their time. But also, I would like to express my really appreciation and admiration for the ingenuity of Swati Mehta, who is also joining today. She's the former director of the Justice Program at Pathfinders, and she's the one who conceived the brilliant idea of compiling these notes in the first place. Because bringing practice notes to life takes not only good ideas, but also commitment, collaboration, and a shared belief that justice system can and must work better for people. This launch today is not just about introducing a new set of documents. We are really trying to advance a way of thinking and, more importantly, a way of implementing people-centered justice. Since the Justice for All report came up, we have consistently made a case that justice should start with people, with their life experience, with their legal needs, and the real-world problems that they try to solve. That framing has gained remarkable traction, and high-level political commitments have kept on coming in the last few years. But as people-centered justice moved from a concept to a commitment, a critical question continues to keep coming. What does it really look like in practice? And this is where we hope that the tools that we are presenting today will really come in handy. Because these practice notes are intentionally practical. They are designed not just an abstract theory, but really a hands-on guidance on tools for policymakers, practitioners, civil society actors, and reformers that can actually use. They help translate values into decisions and principles into day-to-day work. Because advancing people-centered justice is not just about what we believe, it's about how we design, implement, and evaluate justice reforms. Without practice guidance, even the strongest commitment risks remaining aspirational. This is also where the links with open government become essential. People-centered justice and open government share a common foundation, the idea that institutions exist to serve people and that legitimacy comes from responsiveness, trust, and results. Transparency, participation, and accountability are not adds-on to justice reform. They are essential enablers. Transparency helps people understand their rights, the rules that affect them, and how decisions are made. Participation ensures that reforms are informed by those who experience justice problems firsthand, especially communities that are often excluded or undeserved. And accountability is what turns promises into practice. Just as importantly, there is no single blueprint for people-centered justice. It's all about context. Legal systems differ. Political and institutional realities vary. We hope that this practice note will help navigate that complexity without losing sight of the core values. The event today is an opportunity to explore how this practice note can be used, tested, strengthened, and adapted, because these are not final products. They are a living resource that we hope will evolve to learn more from implementation and from one another. So once again, on behalf of Pathfinders, thank you for the co-sponsors. Thank you for the time to be here with us today. I really would look forward to the discussion and to learning together. Thank you, and back to you, Themba.
Thank you, Fernando, for those great opening remarks that really frame this discussion as we are looking at these practice notes and, as you say, taking it from theory, from principle to practice. And when these notes were drafted, when they were created, they acknowledged that people-centered justice means and requires different things to different actors within the spectrum of those that deliver these justice services. And so we identified some of the key actors. And I think it's important to note that it does not mean that this is an exhaustive list. There are other, actors and players within the value chain for people-centered justice that will also, implement people-centered justice. And perhaps in future, we will build out more practice notes for more stakeholders. But this is what the point of departure was. We looked at what the judicial perspective was, and how people-centered justice can be implemented from that vantage point. We also looked at ministries of justice, external funders, and the type of investments they make towards supporting and promoting people-centered justice, as well as international program implementers. Again, they are a different type of a stakeholder that are very active globally in implementing programs, and what are the opportunities for them to approach this in a way that puts people at the center of justice systems. And of course, there's the legal and policy framework, as well as other stakeholders that are involved from an institutional reform perspective that needs to be produce a conducive environment for which people-centered approaches can thrive in. And so what we've done is we're going to start off this session by having from hearing from experts that are representing those different perspectives, and they will share how their work in implementing people-centered justice relates to these practice notes. After we hear from these experts, we want to open up the floor because we want to hear from you all. We want to hear your questions, your thoughts, and also your own experience around implementing. We will be sharing these practice notes for you to engage with going forward, and we're very open to collaboration as well. So without further ado, let us get started with our first speaker, Honorable Justice Dr. Joseph Sergon, a High Court judge from Kenya, and also part of the steering committee for the implementation of the alternative justice system policy in Kenya. Judge, welcome very much to this discussion. We're very eager and interested to hear insights from Kenya. And in doing so, I want to pose a question to you that maybe can get us started, which is, particularly as I mentioned, the practice note on the judiciary. This one encourages judges and courts to work more closely with other justice service delivery actors and to better respond to people's needs through this collaborative process. In your perspective, Judge, what does effective collaboration look like in reality and in practice? And where do you see realistic opportunities for courts to engage with other actors while remaining within their judicial role and preserving that mandate as well? So over to you, Judge.
Thank you very much. The effective collaboration involves, of course, judges, judicial officers, courts working with other actors to address the people's needs holistically. And in practice, this could look like, one, we have the multi-door approach. One is that we diversify dispute resolution mechanisms. Courts offer mediation, arbitration, and other ADR mechanisms like AJS. Court annex mediation, parties can resolve disputes through mediation with trained mediators. Options for litigants to choose between litigation or alternative methods like mediation or AJS. And of course, there is the item of effective case management, which reduces now case backlog and promotes faster resolution. Court users committees engage with communities, police, service providers. Court users committees in Kenya promote people-centered justice by engaging stakeholders, involving judges, magistrates, police, prosecutors, lawyers, and community members. In these court users committees, identifying challenges, addressing issues like delays, corruption, or lack of access. It also involves itself in improving services, enhancing court efficiency, transparency, and responsiveness. Courts should use friendly. Courts should be user-friendly and approachable, raising awareness, that is educating communities on rights and court processes. CUC, in short, helps courts understand and address user needs, making justice more accessible and effective. We also look at the integrated service delivery, that is co-locating services like legal aid. Legal aid promotes people-centered justice by increasing access, ensuring that vulnerable groups can access legal services on pro bono basis, empowering individuals by providing information and representation, addressing inequalities, bringing gaps in legal representation, in bridging gaps in people's legal representation, focusing on the needs, that is tailoring services to client circumstances. Opportunities for engagement. One is using the pre-trial processes, collaborate with the police, prosecutors for diversion or restorative justice. When it comes to sentencing, work with the probation and social services for rehabilitation focused outcomes. Community outreach, educate people on their rights and access to justice. Courts can engage with other actors while maintaining judicial independence by one, facilitating, that is enabling access to services. Also doing coordination, streamlining processes with other actors. There is also the element of oversight, that is ensuring that rights are protected. In Kenya, examples include court partnerships with organizations like the Judiciary Court Users Committee and collaborations with non-governmental organizations for legal aid. In conclusion, in Kenya, judges and courts work with other actors to address people's needs through court user committees, that is engaging stakeholders like the police, prosecutors, and communities to improve justice delivery. The other aspect is promoting the multi-door courts, that's offering mediation and alternative dispute resolution mechanisms. Partnership with NGO and legal aid providers, enhancing access to justice to the vulnerable groups, collaboration with probation and social services, that is focusing on rehabilitation and restorative justice. And the examples is that we have the Judiciary Strategic Plan, which emphasizes on stakeholder engagement and people-centered justice. Finally, court-linked mediation, that is reducing the backlog and improving outcomes. Community outreach programs are promoted, that's educating on rights and access to justice. This collaboration helps courts understand and respond to community needs while maintaining judicial independence. Thank you.
Thank you very much, Judge, for that great overview and insights from Kenya. There was so much of what you said that resonates with this practice note, from calling for court-annexed mediation and alternative dispute resolution mechanisms, making sure that there's provision of legal aid, and the court's role in collaborating with stakeholders, including the police, social services, NGOs, and other stakeholders within the broad spectrum, gives a holistic approach to how people experience and people's justice journeys. My favorite quote from you was, "Courts should be user-friendly and accessible." And I think that's very important, as they can be quite intimidating and complicated when people-centered approach is not taken for judicial service delivery. It was very helpful to see how some of these examples tied in, and Kenya and some of the work you're doing is actually cited in the practice notes as one of the examples of how people-centered justice can be promoted from the judicial perspective. So we thank you very much for those very clear remarks and opening to get us started today. As I said, there'll be a question and answer session. So for those that are watching or are engaging, please, if you have anything you want to ask the judge about his work and the judiciary in Kenya, you'll have an opportunity coming up soon. Next, we move to the practice note that focuses on ministries of justice. And to help us through this is Shahid Koji. He's the coordinator of the Justice Sector Coordination Office in the Office of the Attorney General and Minister of Justice for the Republic of Sierra Leone. Sierra Leone is a member of the Justice Action Coalition and also a founding member of the African Alliance for People-Centered Justice. And so this is a country that has been leading in the people-centered justice approach. And we'd very much like to hear from you, Shahid, around practice note number 2, which emphasizes the importance of evidence-based approaches to justice strategy, policy, and program development. Could you share how evidence informed Sierra Leone's justice sector reform strategy and whether any of these approaches are in the practice note, are reflected in the practice notes in the process that you undertook in practice? So over to you, Shahid.
Right, and thank you so much, Temba, and hi everyone. I hope you can hear me loud and clear. Greetings from Sierra Leone, from the Office of the Attorney General and Minister of Justice. Happy that we're meeting for the first time this year. And so happy New Year to all of us. And Temba, thank you so much for the question, and Fernando and Swati, long time. So thank you so much. And straight to the point. So basically, evidence is quite key in relation to what we do. And the practice note too has most certainly zeroed in on that. And we're happy that what we actually do resonates with what's been captured in the practice notes. So it's also going to be a guide for us and all that. But as we all know, during the development process of our sector strategy, and we basically started off by understanding what people's lived experiences or justice journeys are. So we moved away from just focusing on institutional performance, but then actually looking at people's justice journey. And as a result, there was a simple question that we posed to ourselves, what justice problems do people actually face and how do we try to resolve them? Because we are moving from implementing a fourth generation strategy and then into a new sector strategy. So we had an opportunity of reviewing, having a state of justice assessment. Assessing what we did, the challenges we faced in the implementation of the previous sector strategy, and then taking those ones in account and then developing a new one. So that was really going to be based on data, evidence, talking to people, assessing what we've been able to achieve and all that. So that was a good start. And it's actually, we ushered in a new government. So that created an opportunity to also know what the priorities of the new government was at the time. So to answer the question in terms of what really, or how do we really resolve people's problem? We looked at various perception reports in addition to assessing our previous sector strategy that had done its life cycle. And we also looked at the security services delivery in Sierra Leone, because our sector is such that we work with the security. So it's usually justice, security, and judiciary. And as a coordinating office, our work are quite interrelated. So we looked at the security sector delivery, how far they've been able to deliver on security sector reform through the Office of the National Security, which is the ONS. And we also evaluated the justice and security needs and then the experiences of the citizens itself. So the development of a new sector strategy gave us an opportunity to interact with people outside of capital. And then we also looked at the data needs and community consultation. As you're aware, our justice sector architecture is such that we have the legal aid board that work directly with people. We also work with other community justice players. So we looked at the legal needs, and then we worked with community consultation, and we identified what the common needs were or common experiences, taking into account the formal and injustice formal mechanisms. So we particularly focused on land issues that are very prevalent around here, especially outside capital. We looked at family matters. Legal aid board concerned a lot with family issues, inheritance, small commercial issues. These are actually things that, if they're not addressed, will clog up our justice system. So we looked at those. And the data revealed the important gaps in access and justice and outcome. We also went further to look at, we analyzed administrative data from the justice institutions themselves, including the courts and the tribunals. And this helped us to understand why there are certain delays in justice delivery, and how do we tend to navigate the system and make sure that, the system responds most adequately to the justice needs. But most importantly, we also heavily relied on the qualitative evidence, that is insights from judges. And our system is such that you're going to have to get the view of the judges, because they are the benchers. They sit there, they see cases coming in. If you want to pass a new, and Child Rights Act, you're going to have their views. And so in our consultation, we make sure that we include the judges, we include prosecutors from the State Council. Most certainly traditional leaders are very important, civil society organizations, and those that are actually the front runners, the justice providers that interface with the people out there. So by these mechanisms, we're able to understand why people make the choices that they do, and then also including why many people never enter the formal justice system. And by doing that, it's helped us to know how do we, balance the scale between justice and then the formal justice mechanism and the informal justice process. And, the process most certainly reflects several of the principles as contained in the practice notes. And one is the emphasis on prevention and early resolution. So we don't want to be just, reactive. We needed to be very proactive. And I think this actually has been well captured in the practice notes. And so it resonates with what we're doing. And then the evidence showed that many disputes escalate unnecessarily, which is why our strategy places greater emphasis on mediation and community-based resolution and legal awareness. And that's the more reason we're even developing a mediation bill. And most certainly it's going to be passed into law. And absolutely the legal awareness, understanding what people's legal needs are, providing them and the alternatives, and it's been quite helpful. Another principle I would want to mention is recognizing that justice does not flow through a single pathway, and that our strategy reflects the practice notes focus on people's justice journeys, acknowledging the role of traditional leaders, the administrative setup, and informal justice mechanisms along with the courts, because we work with these two justice mechanisms. Finally, we adopted the practice notes idea that justice strategies should be interactive and learning oriented. So we are aware it's not static. Things are changing, the world is changing, so we tend to move along the path of change. So we have built-in mechanisms to regularly review our data, to learn from implementation, and then adjust as we get along in our implementation. In summary, evidence did not simply validate the existing assumptions that we have, but then it fundamentally shaped our understanding of why justice reform efforts should be focused, and how we measure success, and not only by institutional outputs, but by whether justice works for the very people that we're serving. In a nutshell, we actually do think and believe that our work and our set of strategy in terms of data gathering resonates very well with the practice notes. Thank you so much.
Thank you, Shahid, very much for that overview. I'm always inspired by all the work that you are doing in Sierra Leone to put people at the center of justice system. Then you may have noticed me nodding a lot as you were speaking, because I was also looking at the practice notes for ministries of justice while you were speaking. And the way these practice notes are designed is that it has like a checklist that a practitioner can really just look at quickly. It sort of commences in that way and then goes into a bit more detail. They're meant to be practical and user friendly in practice notes. And Shahid, as you were speaking, I was going through the checklist and just almost ticking all the aspects that are, we were discussing, that are discussed in this note, such as collect data and understand people's justice needs, adopt an evidence-based approach to strategy, policy, and program development, and simplify processes, use technology, decentralize, and partner with local services. So you touched on all of those aspects as you were going through that overview, and it's really encouraging to see that this will have some value and practical implication. That perspective highlighted the importance of stewardship, how ministries can translate political commitment into system-level reform, resource allocation, and institutional coherence. But one thing that is true in many countries, particularly in the global south, is that justice systems are really operating within domestic policy silos. Financing, partnerships, and external support also shape reform trajectories. And this is where external funders can play a critical role. So moving forward to the next practice note that looks at external funders and their role, I'm very pleased to welcome Andrew Solomon. He's the founder of the Rule of Law Ideas Collab and was formerly spent many years as a senior rule of law advisor for the DRG Bureau in the rule of law for USAID. So Andrew has a wealth of experience in having implemented programs from all over the world. And we're very interested to hear from you today, Andrew. Again, of course, reflecting on that practice note 3 around external funders, which candidly states that, top-down efforts by donors to impact rule of law norms, and I quote, do not often result in improved access to justice for people on the ground. At the same time, evaluations show that community-based service delivery results even in challenging contexts, How should external funders fundamentally rethink where they invest their resources? What would it take to shift funding toward locally led community-based solutions as well, and while also maintaining accountability and impact? So over to you, Andrew.
Hi, everyone, and thanks, Temba, and also congrats to Pathfinders and partners for launching these notes. I certainly share the view that not only are they by definition practice-oriented and instructive in moving people-centered justice from rhetoric to reality and to results, as I say, or as concept to commitment, like Fernando said, I think they're landing at a critical time. We all know that justice leaders and actors are under pressure to improve performance, while more and more facing significant resource constraints, tighter domestic budgets, declining overseas development assistance, and other external funding for justice. And many funders, likewise, are being asked, and perhaps rightly so, to show return on investment, with much greater scrutiny being given to their funding, their planning, and their activities. So I'll reflect on this note that speaks to the external funders, as Temba said, based on my decades-long experience as a former bilateral donor, most recently at USAID, where we were moving the design, the delivery, and the financing of rule of law assistance in a much more people-centered and locally driven direction. So about this practice note, I want to start with the uncomfortable truth that it plainly states that top-down, donor-driven efforts to strengthen justice systems and services do not necessarily, and have often, not translated into better justice outcomes for people. And there's evidence there. And we also have evidence that indicates that that community-based, locally led type of justice service can often deliver the measurable results that matter to people. I also like the note because it invites funders to confront another hard reality that for decades, in many cases, they have arguably overinvested in the institutions and underinvested in navigate or facilitating people's justice journeys in cost-effective ways that meet their needs. So this doesn't mean abandoning the institutions. Justice institutions continue to be fundamental to upholding the rule of law. And I want to be very clear on that point. But what I believe it does mean is it is time to rethink and to rebalance our portfolios so that institutional reform and capacity building do not crowd out people-centered and locally led justice systems. Rather, it should be supporting it. And if the goal is better justice outcomes, and I really think it should be, the resources must flow first to where people actually seek and experience justice, not only where the state is formally delivering it. So I hope that helps answer the question, where the funding, might shift or should shift. Now, for the second question of how to do the shift while maintaining accountability and impact, this is one that donors and funders can often find quite hard, and I can understand why, candidly, because inside a donor, three risks loom large and have to be managed. It's the fiduciary risk along with political risk and a measurement risk. So for the remaining my time, I want to suggest 4 ways that external donors and funders might shift the funding while managing those risks and then safeguarding for accountability. But the first, and at the risk of sounding a little provocative, dare we redefine accountability? I think we all agree that donors and our partners must remain accountable, but perhaps accountability should be to the outcomes, not just to the inputs and the outputs, like one we always used before, a number of judges trained. So I think shifting the funding to more community-based activities and local providers can meet the accountability standards when it's grounded in the results like resolution, satisfaction, and fairness and openness, and always where it's user-focused. Second, might we fund ecosystems more rather than just the activities? Because I think we know locally led justice solutions are rarely the work of a single standalone actor, and they tend to result from collective action of the civil society organizations, paralegals, and definitely customary actors, as well as the courts and local government. So I think funding needs to reflect that reality, rather than forcing artificial silos. And collaboration and partnerships are key in the national system and then also internationally. Third, how about we finally simplify procurement and compliance for local actors? Because many community-based and local justice providers are effectively excluded by a lot of the funding that's often designed for the larger and sometimes international actors that are based in that capital city. So, and I also want to be clear here that I still think there's an important role for the international actors to mobilize resources and deploy expertise and to support reform at scale. But if we want that local ownership and local solutions, the donors must design the funding and the reporting so that local actors can really access them and use it. And then lastly, let's keep investing in the data, the learning, the adaptation, and the scale. So we know local community-based justice works because it can adapt in order to be more fit for purpose. So donors should continue to finance, if not increase, and design for iteration, the data collection, and the feedback loops and scaling through learning, rather than tying everything to these rigid and predetermined results frameworks. So I don't think this weakens donor accountability. Happy to hear others' views, but I think it strengthens it because it aligns the funding with what we think actually works. So I'll leave it there, and happy to engage. Thanks for your attention.
Thank you for those nuggets. That was very insightful points you made. I want to reiterate a point you made as one of the points about that. This doesn't mean abandoning justice institutions, but rather rebalancing the portfolio to support justice outcomes, which I thought was very important for us to in messaging as well. And also your very practical 4-point how to guide is something I took a note of as well. Redefine accountability and that word again, the outcomes. Fund ecosystems more, so looking at collective actions, simplify procurement and compliance, and keep investing in data, never stop learning. So this was really very good, interesting. Thank you very much for that important lens, Andrew, because financing decisions do influence what gets prioritized, what gets scaled, and what gets sustained. But resources alone do not determine impact. How reforms are designed and implemented on the ground is equally decisive. And as you said, Andrew, there's definitely a very key role that international implementers play as they help to translate strategy into programming. And that's why note number 4 looks at this key stakeholder. And to hear more about this, we have Evelien de Bruin. She's an engagement advisor with the International Development Law Organization. Evelien, welcome, and thank you for joining us today. Evelien also spent a lot of time working on these practice notes as well, and so we thank you for your efforts in helping us through that consultative process where many stakeholders gave of their time and expertise into shaping these practice notes. And so practice note number 4 on international program implementers emphasizes that international implementers are particularly effective when they prioritize partnerships rather than competition or duplication of efforts. Do you have examples from the IDLO perspective or otherwise where your organization has partnered with local organizations or other implementers to deliver people-centered justice in a way that wouldn't have been possible by working in a silo? In what ways are these lessons reflected in the practice notes? Over to you, Evelien.
Thank you so much, Themba, and thanks for organizing this panel and for inviting us to speak. So thanks to all the other speakers. I think the points I'm gonna say, they will complement you, but also a lot of what you have said really resonated with my experience. So I'm very happy to today represent IDLO, but as many of you've known, I've also have experience with other justice organizations, including as a donor Ministry of Foreign Affairs. So it's very exciting to now see how discussions from a decade, let's say, on people-centered justice, how this is evolving, and now these guidance notes exist. So congratulations on that process. I also believe that these guidance notes are very also complementary to many of the tools and the methods and the approaches that many national institutions, national partners organizations, and also international organizations are using. So for IDLO, people-centered justice is is a key principle that guides our work. It is really, we've heard it already before, but it's really built around the understanding that individuals around the world, they all use different kinds of pathways to resolve their disputes. Courts, institutions, but also traditional systems, community groups. So to be effective, justice systems, they really must be grounded in the lived reality of people and the challenges that people face. Now, to come back to your question, thanks for that. The question, I think it also very much builds on one of the points that Andrew made about funding the whole of the ecosystem. And obviously, this doesn't mean funding one partner that will then consequently support the whole ecosystem, but it really means targeting all these different actors who are necessary to advance people-centered justice. So I'll try to speak to this a bit as well, since also in IDLO, it's really our experience that the most sustainable interventions are the ones in which we work in true partnership with national partners, be it national institutions or civil society organizations, local organizations, but also our international partners. And also, this is to build on also something that Shahid spoke about quite a bit. If we truly prioritize addressing justice needs, we need to ensure we work based on a understanding of what these needs are, but also a common and a shared and a joint understanding of what these needs are, because only then we can jointly decide how they can best be addressed, how building on the diverse roles, diverse mandates, and areas of expertise that we all have to offer. Maybe just a little side step out of my representational role of IDLO. As some of you might know, I also currently work at a trauma clinic where we support people with severe trauma. And I thought it's a useful sort of analogy or comparison to make with the health sector, because if someone comes in with complex needs, you always start using various tools that exist to make a proper diagnosis of what the problem is. And then there's evidence, and the different therapists and support providers that are engaged in supporting the person with the complex trauma, they all need to have the same understanding of what the needs are. And then there's evidence-based approaches and tools that each of them can apply to serve the person. So I thought, as I was preparing for this presentation, I thought of there's many lessons learned from the health and the mental health sector also. Not to say that sector is perfect, because and that it's a one-on-one comparison, but I wanted to mention it anyway, because there it's sometimes a no-brainer that you do it, and sometimes somehow in other sectors it is not yet. So that's why I'm very grateful also for that. Actually, each of the speakers really pointed out the importance of that. So as I mentioned, to go back to IDLO, we partner with governments to ensure that laws and institutions are inclusive, equitable, and in tandem, we also work with communities and individuals at the community levels to really claim their rights and address their justice needs. And as I mentioned, we also work very closely with international partners because it is so important to pool resource and expertise, strengthen convening power, and maximize impact. I'll say a little bit more about that later. Maybe just to share a couple of very concrete examples where we've tried to really advance people-centered justice, working based on these principles. To start in, for example, the Ukraine, IDLO is leading this consortium with different partners, Asser Institute Center for International Legal Cooperation and the Netherlands Helsinki Committee, and they all bring their own expertise to particular justice program. It combines accountability support with justice sector reforms that really embed people-centered to survivor-centered practices, also working a lot with Ukrainian organizations. And it works across the justice chain, prosecutors, investigators, court, probation, prisons, really trying to leverage on the partners' expertise to play this convening role. And the reason why this partnership model was designed as such, because no single organization, even with the best expertise, could credibly cover this full ecosystem that we've been talking about required for people-centered justice. So each of these partners, they bring specific expertise, comparative, and through this structure, we can exploit this comparative advantage. and enhances convening power. So joint expert consultations and policy dialogues brought together different institutions that maybe otherwise wouldn't on a regular basis work together to really develop a joint vision, joint strategy, and to be hopefully much more effective in addressing the needs of the people and survivors in the Ukraine. Just another example, this was working with international partners, maybe another example, maybe in Uganda, to highlight the importance of really working with our national partners and local partners who understand what the dynamics and what the needs are and what the best way to work with communities are to help them address their needs. The example I want to mention is from Uganda, where we work together with a Ugandan service provider, the Ugandan Law Society. So just a very concrete example of a project that we've engaged with. This was at a landing site on the shore of Lake Victoria, where around 50 fishing families, they were displaced because of land grabbing. And IDLO worked together with the Uganda Law Society's Legal Aid Clinic to support the legal empowerment of these families, to mobilize and defend their rights in courts. As a result, these communities were able to reclaim their rights, and through a series of court orders, their land titles were reaffirmed and their livelihoods were restored. Now, I want to stress this example because it was only possible to have this positive outcome because we worked with this very credible, locally rooted Ugandan organization that was very much committed to long-term engagement and really truly also put the people's needs at the center. I was going to share another example, but in the interest of time, I will not do so. But I do want to mention my other examples from the Sahel. But I want to mention one other, or stress one other, I think, important point, actually related to the Sahel. And this is also in relation to the importance of the role of funders and donors to advance this people-centered justice approach. I just want to highlight a specific initiative that is taking place this year, and it's from the Dutch Ministry of Foreign Affairs. I think there are some people also in the meeting here, and I have their consent to mention this. And if they want to maybe add something, they could in the chat or something. But I think it is important. It is almost, when I was reading again Guidance Note 4, it is almost as if the Dutch Ministry of Foreign Affairs has been reading Guidance Note 4 and took it as their the basis for this this initiative, which is quite interesting. But so just like most donors, they've been funding had different justice partners in specific countries, and always obviously had a role, the importance of coordination, collaboration, etc. It always comes up, and with the best of goodwill, and very often successfully, but also sometimes challenging international organizations. They try to coordinate their work as best as they can to align their work with the needs of national partners and obviously people-centered justice needs. But now the ambition level is actually much higher, and it is the funding structure that the Dutch are introducing will make it it could be very conducive to really advancing people-centered justice. So basically, with a specific set number of partners that will be funded for sure. So there's no competition. Together with the embassy, in, for example, Mali, we are being asked to work jointly to develop a joint collaboration framework in which we set out our joint objectives, for example, joint theory of change and our comparative advantages. How will we, each of us, building on our own mandates, on our own expertise, on our own comparative advantage, how can we work together to achieve those objectives? And a very key component, I think, of this approach is exactly what we've been talking about, is do this based on joint data collection, joint monitoring of where are you going, outcome monitoring, as Andrew also pointed out, collective impact measurement, and hopefully this way to make much more effective use of the limited resources that we have to truly support local partners, people's needs, and institutions that are involved at the country level. So obviously the ambitions to work together, they're not new, but the way in which this funding is now being organized, opportunities arise for true collaboration with each others and the national partners to advance people-centered justice. So we're very grateful and happy to work with partners on that initiative, and I thought it was relevant to highlight because it really speaks to the level of ambition that these practice notes, I think, also speak to. So looking forward to the rest of this discussion and to keep working with all of you to advance this agenda and particularly make a difference in people's lives. Thank you.
Thank you, Evelyn, for that really great overview, for taking us out of the justice sector a little bit and giving us that really good trauma analogy, focusing on diagnosis and understanding the problems and having an evidence-based approach. I think is always a very strong reminder. This juxtaposition with the health sector is something that keeps coming up more and more, where we can obviously learn lessons and improve in the justice sector. We are seeing that happening in financing as well, with the justice financing framework, for example, drawing inspiration from the health sector, amongst other things. And those are really good examples from IDLO. Thank you for us learning more about what the examples from Ukraine and the consortium that was developed there, and the locally led or locally collaborative solutions in Uganda are really quite what, as you say, speaks to these practice notes quite strongly. And finally, for that Netherlands MFA funding approach, it's something I think many of us are hearing for the first time, and it's exciting to know that things are moving in this direction. It's very encouraging. So thank you very much, Evelyn. This implementation is where aspiration meets operational reality, and where engagement with institutions, communities, and political contexts become more concrete. But beyond that, beyond the individual programmings, or is the broader institutional reform processes, whether it be legislative or regulatory or structural. And this also shapes whether people-centered justice can take root or not. And that leads us to the final perspective from the practice notes. And of it, last but certainly not least, as Swati Mehta, she's the regional lead of Asia and the Pacific for the Open Government Partnership. But before that was with us at Pathfinders, and she started this work, and we're happy to have delivered and finished the work now. So Swati, we're very happy to have you, but also we want to hear from you around the final practice note that looks at policymakers and other stakeholders engaged in institutional reform. The note emphasizes that effective institutional reform requires meaningful participation from civil society, frontline workers, customary justice providers, and community leaders, not just government institutions. But of course, government institutions are very key, are key to all of people-centered justice programming. So what are the most effective mechanisms you've seen for ensuring that institutional reforms are genuinely responsive to people's needs? And is this reflected in the notes at all? Over to you, Swati.
Thank you, Themba. And congratulations to Pathfinders on the launch of these practice notes. They are timely, practical, and much needed. Of course, I'm not biased because I was never involved with Pathfinders, but there it is. Let me start with a simple observation. Institutional reform rarely happens in a vacuum, right? They tend to happen either in response to crisis. There's a wrongful death in police custody, a corruption scandal, a massive case backlog. Public outrage creates the political momentum for reform. Or it could be driven internally by institutions themselves. Courts want more autonomy, or digital systems, or police wants more resources. Of course, reforms are and can also be encouraged, sometimes pushed by civil society and international development partners. All of these entry points matter, but they do not automatically lead to meaningful change. So when do institutional reforms actually transform people's experience of justice? The evidence indicates that reforms lead to meaningful change when 5 conditions come together. 1, when reforms are domestically led and politically owned. External support can catalyze change, but durable reform must be anchored in domestic political commitment. Without domestic ownership, reforms remain pilot projects. And I think the practice note is clear about this, emphasizing long-term commitment and realistic resource envelopes. Second, when reforms are coordinated across the justice chain and connected to people. Justice is not one institution. It is police, it's prosecution, courts, prisons, legal aid providers, customary systems, paralegals, and community actors. So if we digitize courts but legal aid is unavailable, people still cannot access justice. If police reform but prosecutors don't adapt, bottlenecks remain, so on and so forth. So the practice note, I think, highlights the importance of coordination across institutions and for what we might call a no wrong door policy. And I think both Justice Sargon and Shahid talked about these things. People should not have to navigate institutional fragmentation. Justice sector coordination mechanisms, one-stop shops, clear referral pathways, strong links between formal and informal providers. These are the mechanisms that close the justice gap. And critically, they must work with civil society and local actors to bring justice closer to communities. Third, when reforms are based on data and evidence, especially data about people's experience. Now, too often reform is based on institutional metrics, number of judges hired, number of courtrooms built, number of cases processed. Those metrics matter, but they do not tell us whether people feel heard, whether they understand processes, whether they can afford fees, whether they were treated with dignity. The practice note emphasizes legal needs surveys, user satisfaction data, and that is important. I think from a OGP perspective, Open Government Partnership perspective, transparency and open data are transformative tools here. I mean, I don't want to take too much time, but UK, for example, recently opened up a broad call for evidence on how to strengthen open justice, inviting judges, lawyers, journalists, and court users to shape reforms. This matters because such tools shift reform from being internally defined to publicly shaped. Fourth, when reforms improve transparency, participation, and accountability. And I think this is where OGP's core values intersect directly with Practice Note 5. Fernando, you said transparency is not abstract, it's practical. Do people know how to file a police complaint? What happens if police refuse to register it? Where can someone report a demand for a bribe? How can someone challenge judicial misconduct? These are simple but powerful questions. Justice systems can improve trust dramatically by clearly publishing this information online, offline, in accessible formats. Participation is equally critical. Participatory budgeting processes can be a critical tool to address issues relating to crime and policing. Involve communities in deciding spending priorities for policing and prosecution. Police systems that consult communities on local priorities tend to be more trusted. It is important also to remember that not everyone goes to formal courts. I think both Shahid and Justice Sargon mentioned that. And to remember that not everything requires lawyers and experts. Paralegals and community leaders can resolve minor disputes, provide basic legal information, help people navigate administrative systems, link communities to legal aid providers. The practice note is explicit in recognizing the value of informal and customary justice providers and in urging institutional reformers to engage with them meaningfully. Accountability is the third pillar. Justice actors must not appear above scrutiny. Civilian oversight of police, complaint mechanisms for judicial conduct, lay visiting systems where community members can visit and monitor prison conditions. These mechanisms do not weaken institutions, they legitimize them. The Northern Ireland example, which is cited in the practice note about the independent civilian police oversight, demonstrates how accountability can rebuild public trust after crises. I think the last and the fifth point to be kept in mind is that meaningful change occurs when reforms keep people and not institutions at the center. Let me give a very simple example. Imagine you're building a courthouse. Who's it designed for? Judges and lawyers or litigants? Is there clear signage, a help desk for self-represented individuals, information on legal aid, fee waivers for indigent users? child-friendly spaces, accessibility for people with disabilities. People-centered reform means asking these questions even when you're doing something as basic and technical as constructing a building. It means recognizing that dignity, clarity, and accessibility matter as much as efficiency. Again, for me, Practice Note 5 reflects this user-centered lens, emphasizing justice journeys, respectful treatment, simplified processes, and digital tools that are equitable. Let me conclude this. Institutional reform is often framed as a technical exercise, but it is fundamentally about power. Who defines priorities? Who is heard? Who can challenge decisions and who benefits? The most effective mechanisms that we have seen: structured multi-stakeholder platforms, open data and feedback loops, participatory priority setting, independent oversight, community-level code delivery, all have one thing in common. They share power. They create space for people not just to receive justice services, but to shape them. And I think Practice Note 5 provides a thoughtful roadmap for doing exactly that. And from the perspective of OGP, its message could not be clearer. Justice institutions build legitimacy not by reforming behind closed doors, but by opening themselves to participation, transparency, and accountability. That is how institutional reform becomes people-centered, and that is how we close the justice gap. Thank you.
Thank you, Swati. This was a really great overview. Really enjoyed how you articulated those 5 key pillars and related them to the practice notes, and it was really good to see that comes out. Some very important aspects you mentioned about when reform really takes place. It must be domestic led with practical commitment. Must exist across the value chain. People should not have to navigate institutional fragmentation. I thought was a really great quote. You said data and evidence are a recurring theme throughout this discussion. So it's clear, it's quite strong. Trust, participation, accountability are also very important. And last but certainly not least, place people at the center of justice systems. So thank you very much, Swati. We appreciate those remarks. And in the interest of time, I'm going to transition quite quickly to the Q&A session. We don't have a lot of time, so I ask our speakers to keep your responses as direct or succinct as possible. Folks have already started putting in some questions in the chat, so I'm just going to go through all of them, and then I'm going to open the floor for some responses. The first one says, in response from Sunil Pal, in response to what sounded like Andrew's distinction between investment in institutions and investment in people and their justice journeys, should such a distinction exist? Should institutions not also be designed or adapted to people's justice needs? So I think, Andrew, if you like, you can maybe respond to that one. There's another question from Cheryl. It's saying, in many African contexts, there's a gap between formal rule of law institutions and the people they serve. How do these practice notes provide a roadmap for institutions to integrate innovative community-led solutions like those we support at Justice and Innovation Africa? Another question, so that's an open question, I believe. Another open question: what are evidence-based approaches to determine the legal reparations for communities disparately impacted by performative justice leadership? Further, what are the horizontal measurements for lack of accountability? And then a question that's specifically for you, Evelyn. How has your experience of cooperation with local authorities in Mali, given the ongoing erosion, how has been your experience given the ongoing erosion of civil liberties? I'm very interested in this. This is as the UN independent expert on human rights in Mali, Eduardo Gonzalez. And then final question: in India, people shunt from going to police stations to lodge complaints for fear of being mistreated. So I think that's just a comment about some of the challenges that happen when there isn't a people-centered approach. So as I said, I just put out the questions there. There's some specific questions and then others are open. I'll start with you, Andrew, and then, please feel free just to chime in as the speakers if you have some responses to those questions. Over to you, Andrew.
Sure, they're all very good questions. On the first, about people-centered institutions, I think in many ways Swati, at least I heard Swati addressing this and answering it, so I don't want to take up too much more time. But no, indeed, I think there has to be complementarity and a relationship between the institutions, and outside and the public with this. And I mean, we know this type of phrase that in many ways we have, at least in the justice sector, 18th or 19th century institutions, based on the laws, the practices, the procedures of their, built by and for lawyers and judges, not necessarily the people. So indeed, a lot of work needs to go into transforming the institutions to be people-centered in the development of their policies, their practices, and the delivery of their services. And I think we are making that that transformation, or at least progress there, as evidenced by who we have on our panel with us today. So I don't want to get too much more into this, but it is institutions as a bureaucracy. Yes, you need to change mindsets and behavior. That frankly takes leadership, and I think it's also going to need generational change. So I remain hopeful. There's other tools, design thinking that we can use. And then, yes, Swati, I loved your reference to the courthouse. Again, many ways built for the people who work inside it, not the people who need it. So whether it's procedural justice, in like proceedings, or in just, the flow and the approachability. So those are important things. I hope I answered that question.
Yeah, thank you very much, Andrew. Are there any other reflections or responses that the speakers want to share? Yes, Eileen, I know there was a question specifically for you, so please go ahead.
Yeah. Thank you so much for that question. I just also wanted to acknowledge it. Eduardo, I think, so in Mali, I'm not an expert on our Mali program, but I'm really happy to connect and to get you in touch with the people who really work closely with institutions and communities on the ground. What I know is that we are working not only with local authorities, local institutions, but also in sort of coordination platform where we bring together at community levels, local authorities with traditional authorities and community groups to really convene together to identify solutions for the most pressing justice issues. But maybe not to go into too much detail on this now, but I would really like to connect and to have a specific Mali discussion with you yet. In fact, and this is maybe a little bit out of line, but I'm thinking, given the collaboration framework initiative that I refer to, it could be a really great opportunity to actually engage with the justice partners with whom we will be working in Mali with you jointly. To have a discussion about these specific questions, because obviously it is something that we all encounter. And then just a question on the link between the question on the formal, there was a question, the gap between the formal rule of law institutions and the people that they serve. I just want to refer to one experience that we have in Somaliland, where we work with formal institutions, but we also made a specific choice to also work with a local or a national large media organization for like big awareness raising campaigns to maybe also bridge the gap, and to work specifically when it comes to gender-based violence, to work with a network against female genital mutilation in Somaliland, who was really the lead partner for all our programming related to sexual and gender-based violence, women's rights, and child protection. And this really made sure that our program was very much embedded into the people that we wanted to serve, the needs, the cultural context, the sensitivities, etc., etc. So I just to make that point out, to emphasize the point of how important it is with locally embedded organizations who really understand what the needs are, to try to bridge that gap and to do this in a harmonized manner. I hope that answers some of the questions.
Yes, thank you very much. And Yeah, we'll be happy to facilitate any connections like between Eduardo and yourself, and also just in the spirit to say that, you know, we could actually go on talking about these practice notes for much more. I see there's a lot of interest from you all, and this is really encouraging. Unfortunately, because of time constraints, we may have to take some of these discussions offline. We're always open to engaging as Pathfinders, and would welcome any additional comments or feedback following this discussion. However, in the interest of time, I would like to hand us over to our last but not least speaker from UNDP. We have Rewai Makanje Olbeck. She's the global lead and advisor at UNDP, and UNDP has also been a partner of ours in developing these practice notes. They provided extensive review and feedback, which was also very helpful in bringing these documents to life. Rewai, could you please just give us some reflections on what we have been discussing today and on the practice notes, and going forward, what could these mean? How could these work? How can they become practical themselves? Over to you, Rewai.
Thank you so much, Themba. Maybe let me also start by congratulating Pathfinders for this groundbreaking work that you did in the development of the practice notes. I know we are getting towards the end of the session and quite a lot has already been shared, but colleagues, I think one of the key aspects or that really came through and got illuminated in this discussion, but is also really part and parcel of what we have been doing in this community when it comes to the work on people-centered justice, is really very, very clear clarity, even across the panelists and also across the questions that are coming through the chat system, that people-centered justice is not one reform, it's not one actor, it's not one investment. It is really an ecosystem. It's an ecosystem shift. It's a transformation that is intended to change from usually what we call as just simple access to justice, but rather to put people at the center while at the same time working very closely with institutions. And with each and every one of these ecosystems and the systems that we are working with, honestly, I think some of the examples that have been illuminated in the discussion today really are showing the shift of the collaboration from theory to practice. The court user committees and the mediation work in Kenya and the ADR processes that we had from the first panelist today, I think really is an example that illuminates how institution can open doors. I think this is really for us where the work on people-centered justice begins to show this important shift. So institutions are not being insular. Institutions are opening doors and saying, we want to work with people, we want to engage with people. And the development of, people sector, justice sector strategies, such as the one from Sierra Leone as an example, is another excellent example of how information and data that is administrative from the institutions combined with perception surveys, deep listening exercises with communities and people that have justice needs and experiencing different justice journeys is all combined to really create this rich data, information, and evidence that then informs the institutional shifts that need to take place. And perhaps even here then to connect with some of the key points which really absolutely resonate with the work that we do in UNDP in our work on the global program for the rule of law on justice, human rights, and security, that really when engaging with institutions and when engaging with people, trying to bridge that gap, bringing as much as possible these perspectives together, but at the same time being very cognizant of some of the hurdles and some of the institutional resistances that are sometimes in place is critically important. And I do believe, even just from the examples that we have today, also examples from some of the work that we've done within the framework of the Justice Action Coalition, there is an opportunity, I think, to continue to cross-learn from these examples and pushing this work forward. So as far as I'm concerned, these practice laws are very practical. They are focused on very specific stakeholders, but at the same time, I think they are also a resource regardless of whether you are that particular stakeholder or not. I think quite importantly for us is that they will inform practitioners, ourselves, as we engage with the different institutions, as we engage with development partners. And I really like the points that came back from both Andrew Solomon and Swati. We are having a financial crunch. You know, the fiscal space is so limited. It is so small. How do we best leverage the little resources that we have, financial and human resources, to be able to crowd all of this to specifically target some of the key and pressing needs? The exploding number of crises that we are facing globally at this particular point really also puts a lot of pressure on this work. Yes, the examples of the Sahel is maybe perhaps just one outstanding one, where definitely the engagement that is coordinated, where it's more collaboration and working together and less competition, becomes a critical part of how we want to deliver on people-centered justice. For the work that UNDP has been doing, and colleagues, we really are also grateful for the support that you've been providing us, I think over the past 3 years, initially with the development of our policy framework on people-centered justice and security. And just like Shahid mentioned earlier, we really bring this work on justice and security in one breath, noting how interconnected this is and how people's lives are in that spectrum of justice and security, and how that really affects and impacts their work. And then in addition to this, we then developed a people-centered security and justice guidance note for our country offices. The ambition here being to allow the country teams to be able to engage and interface with stakeholders and design programs that really respond to people's justice needs and be influential in an impactful way to people's justice journeys. Now, these practice notes, as far as I'm concerned, are a critical element of this full package of resources that is being developed over the years, and an important and critical reference point. So moving forward, Themba, I do believe that as a community of people working on people-centered justice, the work that is being done at country level, the work that is being done at global level and at regional level, has allowed us to create immense resources. I think where we are now at is how we best deploy these resources, how we best use them, and how we continue to collaborate and work together to ensure that we really deliver on the results that we are looking for. Absolutely, people cannot wait. And disputes have to be resolved. And at the same time, I think the call continues to be very high upon ourselves to fully engage, to fully act, and to be fully responsive and deliver on people's justice needs based on the evidence and the data and the needs that are on the ground. I'll stop here for now, Themba, because I know that the conversation can go on for long, but really appreciate all the comments also coming from the colleagues and the inputs from the panelists. Thank you.
Thank you very much, Rewai. That was such an excellent way to tie in all of the rich discussions we've been having today. We also want to thank our panelists for sharing those insights, for sharing your expertise, and for helping us launch these practice notes. For all of you that have joined us and attended this session, we also thank you for your time and for your great questions. We couldn't get through all of them, but as I said, we're very open to continually engaging with you all. We invite you to engage with these practice notes, to give us more feedback, to help us improve on them, and to start to implement them in your own spaces and your own spheres. So thank you all very much for your time and for attending this launch, and have a good day further.